So, welcome to the webinar today. We'll be discussing issues of delayed payments to MSME, challenges and solutions. What all the challenges they face in recovering the timely payment, and what are the solutions that they can opt for in case they are suffering from these challenges. So, let's start our webinar. So the agendas for discussion in the webinar today would be the definition of MSMEs under the Micro, Small and Medium Enterprises Development Act 2006. We'll be referring it to MSMED Act from now on. The qualifying conditions to apply for registration under the MSME Act, MSMED Act. So the qualifying conditions, when I say, I mean to say that the enterprise under the MSMED Act are classified into micro, small, and medium enterprises, and it is provided, the parameters are provided under the Act, so as to how one enterprise can register itself in any each of these categories, and that qualifying conditions depend on the investment made in plant and machinery and the turnover generated in a financial year. So both the conditions are taken together, and both the conditions has to be met in according to qualify for each of these conditions under the micro small and medium enterprises act. the, Going forward, the challenges and issues pertaining to delayed, defaulted, stuck payments from buyers. So there are a lot of challenges and issues pertaining to delayed, default, stuck payments from buyers, right? So the challenges might be industry specific. The issues might be endless, because the circumstances can be endless, right? What possible challenges are these MSME face in case their payments are delayed or defaulted or stuck from the buyers? So what are the common challenges that they face, and what are the issues that lead to such circumstances in the first place? So we'll discuss those issues also. The important provisions under MSMED Act for the benefit of MSMEs. So as I stated, the Micro, Small and Medium Enterprises Act, as is apparent from the name, is enacted for the micro, small and medium enterprises which operate in our country. And the micro, small and medium enterprises contribute a major chunk to our economy. So it is the largest contributor of the economy by far the percentage is concerned. It surpasses the it has the largest contribution in economy for India, when all the industries or any kind of industries are concerned. So the government and the legislature has enacted this act in by making the MSMEs the center stage, and all the provisions in the act revolves around the facilitation, promotion and development of the MSMEs. So the first chapter deals with how does the government plans to work for the promotion, development and facilitation of the MSMEs. The other part deals with the disputes and how the MSMEs can recover their delayed payments. So the act is drawn out for the MSMEs, and to facilitate them in recovering their delayed payments by incorporating such provisions which are might which we can say that are so detrimental to the supplier, that if they delay on the payments willfully or deliberately, they would have to bear an interest charge which is 3 times the Reserve Bank notified interest, and the interest is charged compounded, that too on monthly basis. So it provides a penal provisions also for the suppliers who willfully and deliberately make delayed payments to such enterprises. And the preventive measures. So all these challenges and issues which leads to arising these circumstances of delayed and defaulted payments. What are the preventive measures to avoid such issues that are common in the MSMEs and the operation of MSMEs? So we'll discuss those. The resolution mechanism. So when these issues have already arisen, right? The payments have already stuck from a buyer, or from a buyer, right? So then what are all the resolution mechanisms that we can opt for? The alternate dispute resolutions, which covers all the resolutions which is outside of courts. So like the dispute resolution, with the alternate way of resolving disputes other than going to courts, are are are, are everything which we can term it as alternate dispute resolutions, right? So it includes mediation, conciliation, arbitration, and even out of court settlements, like the parties mutually mutually discussing and amicably settling this issue. So all of those resolutions, types of resolutions, are alternate dispute resolutions, because you don't go to the court, and there are other ways in which you can recover your payments, that is by going to the courts, which is called litigation. So we have divided these two in we have bifurcated these in two parts, right? So the alternate dispute resolution will deal it separately, and the other aspect would be litigation, will deal it separately. So, and the last part is things to keep in mind while doing businesses for its effective management, tips and suggestions. So these tips and suggestions are nothing but common tips and suggestions, which we, as being a lawyer, can suggest these small tips for you that would streamline, or that would make your transactions in more effective way, right? So we'll close our webinar by giving those small tips for you to effectively manage and operate your businesses. So going forward, so yeah, the condition precedent to be registered as MSMEs under the MSME Act, amended by the notification dated 26/6/2020. So this was amended by this notification. However, the Act is of 2006, but the definition clause was recently amended in 2020 as per the recent notification. So firstly, we have to understand what does an enterprise mean in MSMED Act. So the MSMED Act gives a very wide expression of the enterprise. So it includes, in the first category, while defining enterprise, it includes manufacturers and service providers, both in one category. So if you are manufacturing any goods, if you're manufacturing any sort of goods, be it FMCG products, or industrial products, or heavy industrial machineries for that matter. So all those manufacturer units are also included in the enterprises, and the service providers are also included in the definition of enterprises. So be it a consulting enterprise, or be it a merely service provider like human resources service provider or workforce service provider. So all of those service providers would also be included in the first category, as within the term of the expression, within the expression, which is enterprise under the MSMED Act. The second category, with this amendment, which I recently stated, that 26/6/2020, it was recently amended, and with that amendment, the second category was created, which included traders of goods, right? So who are traders of goods? The traders of goods are someone who is not manufacturing it, but is buying those goods from manufacturer and further resells it to retailer by factoring somewhat profit to himself. So neither he manufactures or nor he is a service provider. What he does is that he buys goods from manufacturer in a wholesale manner, and then it retails it to the retailers by factoring some profit to itself. Those kind of enterprises are traders within the expression of MSMED Acts. Earlier, the traders of the goods were not included in the definition of MSMED Act enterprises, but now with that amendment, the traders of goods are also included within the within the definition of enterprises, and now the registration are also extended to the traders of good. Earlier, the traders of good were not eligible to apply for the registrations as any of these categories, be it micro, small, or medium enterprises, right? Now the traders of goods have been included in the definition of enterprises, but however, the MSEFC, the Micro Small Enterprises Facilitation Council, which is commonly known as MSME Samadhan, that benefit of availing your that 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 benefit which the micro small enterprises, being manufacturer and service providers, can avail, the MSME Samadhan benefit, in which they can go and they can file a reference of delayed payment to MSME Samadhan, and they are eligible to get their disputes resolved through MSME Samadhan. So now the traders of goods are not extended those benefits as of now, because we have tried filing the cases for the traders in MSEFC Samadhan, but they have been returned, saying that these benefits are not extended to the traders of goods. However, the website of the MSME ministry states that the traders are also included in the MSME, but somehow the MSEFC Samadhan is not taking up the cases. So that is the actual stage where it is right now. So it is pertinent to let you know these important uh, important laws, that the law where it stands as of now. The two parameters, as I stated, which classification is made between MSMEs, are investment made in the enterprises. So investment made in the enterprises, when I say, the investment includes the investment made in the plants and machineries or equipments of your machinery, right, of your plant. So any investment that you have made in the equipments or the plants or the machinery of your plant would be taken into consideration as an investment in your enterprise. And the second parameter is turnover in a financial year, right? So in a financial year, what is your turnover is also considered. So the second parameter is the turnover of the enterprise. Now, going to the next slide, this is a table laying out the investment made in the enterprises and turnover generated annually, the limit with which you can get yourself registered under each of these categories, be it micro, small, or medium enterprises. As I stated also, both parameters, investment and turnover, has to be met for an enterprise to qualify as either micro, small, or medium enterprises, basis the parameters laid out here in below. So the type of enterprises, if you are a micro enterprise, or if you want to get yourself registered in micro enterprise, the only condition that you have to take care of is that the investment made in the enterprise should not exceed 1 crore of rupees. So if it is anywhere less than 1 crore rupees, you would be eligible in one parameter, that is the first parameter of the investment made in enterprise. So for micro enterprises, your investment made in enterprise should not exceed 1 crore of rupees. And if we talk about the turnover, now if you are a micro enterprise or wish to get yourself registered in the micro enterprise, you have to take care of this parameter, that your turnover should not exceed 5 crore rupees in any financial year, right? So if both of these parameters are meeting, and if you have made your investment less, if you have made your investment in plant or machinery or your enterprises which is less than 1 crore of rupees, and you have generated a turnover of, let's say, 4 crore of rupees, which is less than 5 crore, the limit, the upper limit, then you are eligible enough to get yourself registered in the micro, as a micro enterprises in the MSMED Act, right? The same is for small enterprises. Now, for micro enterprises, there is no lower limit, right? So even if you have made an investment, let's say, of 10,000 rupees, then it is very well covered under less than 1 crore of rupees, right? So there is no lower limit. The same is for the turnover generated annually. So anywhere less than 5 crores or anywhere less than 1 crore of rupees in investment as plant and machinery, and turnover anywhere less than 5 crores of rupees, you are eligible to get yourself registered under the micro enterprises. But when we talk of small enterprises, the lower limit is the higher limit of micro enterprises, right? So your turnover should be anywhere between 5 crore to 50 crores, right? Because if it is less than 5 crore, then you are meeting the criteria of micro enterprises, right? Then both the criteria of the small enterprises would not met. So your turnover should be between 5 to 50 crores, right? And your investment made in enterprise should range between 1 crores to 10 crores. Now it should not be less than 1 crore, because then you'd fall under the micro enterprises definition. And going further, if you talk of medium enterprises, if you have exceeded the investment made in the enterprises by 10 crore of rupees, or you have exceeded the turnover generated annually by 50 crores of rupees, then your registration would be upgraded, and it would be registered, the enterprise would be registered as the medium enterprises now. So I hope I'm clear in the definition part of micro enterprises, small enterprises, and medium enterprises, and both the parameters of it. Okay, I'll move forward now. So, going to the next slide, reasons for the delayed payments and its consequential effects on MSMEs. So, as I stated, that the issues and the challenges that leads to such issues arise, to which leads to which leads the enterprises to suffer these issues, to suffer with these issues of delayed payments in the first place, are multitudes in number, right? But there are some common mistakes that all the MSMEs in general do, right? So we'll discuss some of those issues, and we'll let you know that how does not how these things, if not taken good care of, can lead to hamper your business in most aversive manner, right? So the first thing is not documenting or recording of the transactions, delivery of goods, materials, or performance of services without any work purchase orders, not recording terms and conditions in an agreement, not adept with quick turnarounds for reserving rights, etc. So I've seen that many micro, small, and medium enterprises enter into huge transactions, which includes huge number of capitals, without any recording of the transactions. When I say without any recording of the transactions, I mean that there is no written record of those transactions happening, right? Like there is no work order generated or purchase order generated for those work or for those services, and there are no invoices generated from your part too while raising the while raising your bills, right? So and when we do not record these transactions in a written form, then we do not have anything to go and to show it to the neutral party, who would be an adjudicating body, that these were the terms and conditions that were agreed between the party, right? So we would miss out on very important things, and many a times we'd miss out on even maintaining such a claim against the opposite party, because we would not have anything to show or to prove that the transaction did happen, right? So there are other ways in which you can prove when a transaction, even when it is not written. That is by conduct of the parties, that is by how the parties have conducted businesses in the past, but that is an interpretational issues which works in both the favor, right? So if you have a written transaction which is already recorded, and both the parties have signed it, both the parties have agreed to it now, then the terms are already recorded, right? The terms have been agreed between the parties, and even if the dispute at any time arises, then the disputes would be adjudicated basis on the terms and the conditions that the parties agreed to, right? And then if the transactions have entered between the party, you have supplied your goods and you have not been paid the whole amount, so it would record that the supply of the services were of this sort, and the price of those services were agreed up to this amount. So you can now go and you can say that, however, I have received this much of payment, but this is not the full payment, because the full payment is crystallized in our purchase order or invoice, right? So there are a lot of benefits when you record your transactions, which you cannot even wrap your minds around, right? Because when you do not have these written transactions, in the absence of these written transactions, the issues which would be faced by you, or the problems that would be faced by you, would be vast in number, when as against when you'll have those written transactions in record to base your claim, or to base your action upon, right, against the opposite party. So any transactions, when it is recorded in written manner, is very much beneficial, and it should be kept in mind that every transaction should have a governing agreement. So when I say that you should generate purchase order and work order for every supply of goods or the supply of services that you're doing, and you should raise bills and invoices against those supply, but those purchase orders and those invoices do not encapsulate all of the things that can go haywire between the transactions, right? So in that cases, the agreement comes as a huge benefit to the MSME. So if you have an agreement already drawn out for any transaction, then an agreement mostly encapsulates all the exigencies that the dispute that might be incidental to your transactions, right? So it preconceives all the things that can go wrong or that can go haywire in your transactions, right? So it includes all the important clauses, like the breach of the parties. So what would constitute as a breach, of contract by each of the parties? What are the obligations of each of the parties? The indemnification clause, which states that the other party, if one party is suffering loss by the action of opposite party, which is not as per or in accordance with this agreement, then the other party would be liable to pay the damages or to pay the losses that the other party suffered because of his actions, or because of its actions. So that is indemnifications. That is indemnification clause, right? And such as there is a force majeure clause. So those clauses encapsulate an exigency where where a force which is not under our control uh, hampers our businesses, because of which you cannot fulfill your obligation, right? So let's consider the floods which we have seen recently. So in Himachal Pradesh, so let's say if your unit was in Himachal Pradesh in a severely flood affected area, then it is obvious, right, that you would not be able to fulfill your obligations at a time when your industrial unit is suffering from a severe flood. Then in those cases, the clause of force majeures comes into play, right? Because it states that it discharges the party from its liability for that much of period where it could not have control the hampering of business, right? So it excuses. So there are other clauses also, right, which might act in your benefit, or which might act as a boon in any given circumstances, right? So if it is recorded early from entering into a transaction, it gives a huge boost to the MSMEs to go on and to enter into transactions without any fear, or without any apprehensions of not getting paid, because the transactions, the terms and conditions of it is already agreed between the parties, and already the dispute resolution mechanism are also agreed between the parties. Like in most of the agreements that you would enter into government enterprises or government instrumentalities, have an arbitration agreement, arbitration clause, right, which is treated as an independent arbitration agreement. However, they have an independent arbitration clause which states that you cannot go to courts, but you'll have to opt for arbitration only in if any dispute occurs, uh, if any dispute occurs in dealing with the transactions entered into between the parties, right? So all these clauses can be entered, can be encapsulated, can be preconceived, and be put into the agreements, which would be very much beneficial to the MSMEs in conducting their businesses and transactions. Now, the second one is the extended credit period. So the extended credit period is nothing but the extended time which is given to the other party whenever you supply some goods, or whenever you supply some services to, let's say, a buyer. Then there is a time limit for them to making the payment, right? The time limit that you give to the other party to make payment for your services or for your supply of goods is called the extended credit period. So it generally ranges between from 1 week to almost 45 days, right? So the extended credit period is something when it is extended from 45 days, or let's say extended from even after 15 days or 30 days. It depends on the transaction and the commercial wisdom of the enterprise. But in my opinion, it should not exceed from the 45 days limit, because the MSME Act, after the 45 days of supplying the goods and services to the other party, makes the other party liable for paying three times the interest rate which is notified by the RBI on the payment which is delayed, or the payment which is due, right? So when the act is giving the 45 days limit, then it makes no sense for the enterprises or the MSMEs to give more credit limit than the 45 days limit. However, you can, by contract, restrict those 45 days limit to 30 days limit, or let's say 25 days limit. But it is your own commercial wisdom. But however the act restricts it to 45 days, then in my opinion you should also not exceed it from the period of 45 days, what the act already states, right? So now the third is the challenges faced due to competition in the relevant market. Industry specific challenges such as disrupted availability, availability of raw materials, etc., competitive rates with minimal margins of profit. Now there are a lot of practical issues that these MSMEs face, right? That do not have any legal angle to it, but those are common wisdom, right? Because let's say if you are dealing in a sweet shop, then you cannot stop any other enterprises from opening a sweet shop in your own relevant market, right? Then you have a competition. Then you have a competition in the quality of the products, and then then you have a competition on the price of the products. So your services would get competitive, right? So these things, these challenges are generally faced by these MSMEs, and there are things that they can do for streamlining and strengthening those competition which they face in a relevant market. So let's say you have exceeded your relevant market by not having a mere physical presence but an online presence too, right? So let's say you have a store in Mayur Vihar, Delhi, New Delhi, let's say, for example, but you have an online presence and you deliver your goods or services to, let's say, all of India. Now the relevant market for your shop or for your goods or supply of services is not restricted to Mayur Vihar, where you are physically present, right? But it is also extended to all of India, where you deliver those services via online mode or via associate offices or via branch offices, right? So these are the things that you can opt for 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 not hampering your businesses too much from these challenges when they arise, right? You can have 2 3 sources of generating raw materials. So let's say if you are a manufacturer of goods and you buy your raw materials from any one source, then in my opinion your one source is very much restrictive when it comes to business, right? Because you cannot be dependent, you cannot be 100% dependent on any one source, be it a source of generating workforce or be it a source of generating raw materials. So in my opinion you should have a pool of resources, right? A pool of resources in from other parts or from different parts of territory, right? Of various territorial jurisdictions, so that you are not dependent on any one territory or any one source for that matter. So let's say in COVID, uh, the whole labor force were disrupted, as we already know. But if, let's say, if you were only dependent on one source or one human resources agency which used to supply the workforce to you, then it would be difficult for you to generate the workforce in these circumstances. But in case you have 5 to 6 sources, then it would be less difficult for you to manage these resources or to get your or to prevent your businesses from hampering in case of strikes of labors or disrupted availability of raw materials, right? For any other reason. Now, next is no bargaining power with buyers to negotiate terms accordingly, market share reductions, alternative materials or services against that of MSMEs, etc. So, when we talk of no bargaining power with buyer to negotiate terms accordingly, we generally speak of the transactions where the MSME, being a micro, small, or medium, not a very large corporate house, enter into an agreement with a large corporate house who commands a well respected goodwill in the market, or is well known to the consumers of the market. So generally, when MSMEs enter into a contract with large corporate houses or such corporate houses who are there in the market for a long time or have a huge market share in their specific industry, then the MSMEs do not have a lot to bargain, right? Because these companies already have their own boilerplate contracts or boilerplate invoices that they would give it to you, and they would ask you to incorporate or to agree to those boilerplate contracts. So you do not have much bargaining powers in respect to negotiate the terms and conditions with those corporate houses. But you should keep in mind that without recording those transactions or without entering into an agreement, dealing with those corporate houses or dealing with any other enterprises without any written transaction is still detrimental to the operations of MSMEs. So even if you have to sign a boilerplate contract, or let's say you do not had any bargaining power to negotiate the terms and conditions with a large corporate house, I would advise you to get into a contract, to sign a contract with those corporate houses. And if any dispute occurs, so it's already a common knowledge, right? So if a corporate houses makes you sign an agreement which is already drawn by them, by itself, then it is commonly known that those agreements would be highly favorable to them, right? The clause would be highly favorable to one party. So that is fine. That is fine in a sense, because in law you can have this interpretational issue uh, get resolved in a court of law, because of certain principles in contract. But if you do not have any written transactions to begin with, that can be certainly be very much detrimental to you, uh, as against having entered into any contract for that matter. So I guess I'm clear by far. Now I'll come to ineffective correspondences during a transaction. Lack of recorded communication between parties, reserving the right to claim liquidated damages, if any, lack of acknowledgement from the buyer regarding unequivocal acceptance, etc. So, ineffective correspondence, when I say, is the correspondences which would help you in proving that you are not at fault at any point of time till the transaction was going between the parties, right? So let's say if you have entered into a contractual agreement to erect a building for a buyer, right? And you being a service provider, you being a contractor, have taken a contract to erect a 5-story building for some buyer. Now, ineffective communication here would mean that if there are delays which are attributable not to you but for the actions of the opposite party, then you should be careful enough, or meticulous enough to be adept with exchanging those communication with the opposite party, saying out loud that these are the actions which have had detrimental effect on ourselves, which have delayed the whole timeline of the contract, because you have not supplied raw materials to us, or you have not given clear access of the property to us. So these effective communications, when made at a time when it is happening in real time, makes a record of the whole transaction, right? So when the opposite party was delaying on its part, like as I stated, that they were not timely delivering you the raw materials, or were not timely delivering you the secure access of the property to get the work doing to get the work going in order to erect the 5-story building, then those communications that you wrote to the opposite party, saying that these delays were attributable to you, and I am ready to mobilize my force and to initiate the construction activities at your premises, but it is your fault that we have not gotten the access of the property, or we have not gotten the prerequisite material to begin the work. Then it becomes clear that it is not your fault, and the losses that you'll suffer because of that fault would have to be bear by the opposite party, because it was his fault, because it was its fault, right? To delay in delivering the goods, or to delay in not giving you the secure access of the premises, right? So these are the effective correspondences that you can do. Let's say if you have supplied some goods to the other party, and there is an extended credit period of, let's say, 40 days. So when already the 40 days period expires, then you should, on the 41st day, write to the other party, saying that the extended credit period is already over, and now from the 41st day you would be liable to pay this much of interest as applicable under the MSMED Act to me, if you keep delaying the payment, right? So these things are effective correspondence during a transactions that you can do, which makes your claim and makes your actions, that if you do in future, makes seamless and without any hassle, right? Because it's already recorded in transaction, right? It's already recorded on a date when it actually happened. So there is no scope of let's say tampering with the evidences or tampering with the records of the transactions, right? So these are the effective correspondences that you can do. The lack of recorded communication, that as I already stated, that if you are not adept with exchanging these communications with the opposite parties, then at times it might happen that you won't be able to prove these things, that the delays were attributable to the opposite party, or the opposite party was at fault in these circumstances, because it won't be recorded, right? So as I stated, the correspondences are very much pertinent when you are operating or you are entering into a transaction with any enterprises. The reserving the right to claim liquidated damages, right? So let's say even a small breach in a contract can have a cascading effect or a dominoes effect on yourself, right? So let's say you have supplied let's say 10,000 kilos of nickel to a government instrumentality. So it is understood that you have procured that material from some place else, right? Or even if you are a manufacturer, then you have manufactured those materials after you have invested a sum of amount, right? So you have incurred an expense in supplying those nickel, 10,000 kilos of nickel to BHEL. Now if you do not get your payment on a timely basis, then you won't be able to realize the investment or the expenses that you have already incurred, right? And if you are not able to realize the payment against those invoices, then you would be in loss, because you won't have the money, the money against those invoice to set off the labor forces, or to set off all those expenses that you incurred while supplying those materials in that PO to BHEL, right? So it would have cascading effect, like you would face liquidity crunch, your workforce might not get timely payments, and the other contracts might get delayed due to these factors, right? So whenever these things happen, it is my opinion, and it is to be taken care of by the enterprises to exchange these communications, saying out loud that these are the losses that we are facing day by day because of your delayed payment, right? So all those claims can be computed at a later stage and can be claimed from the opposite party, because the delayed payment is not the only factor that you that 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 is not given to you. Now, just because it was not given to you on time, you have faced several other losses. So the opposite party would be also be liable to pay all the other losses which you faced, because the payments were delayed from one invoice, right? So all these things you should have to reserve the right through the way of communication, that I have been facing these losses and I reserve the right to claim these losses at a later stage of time. Even if you make the payment against these invoices, I would still be liable to I would still be entitled to ask for all these claims which I faced losses from, right? Which so all the losses that I have faced, I'd be entitled to claim it from you, right? So all these things you should take care of. And even if you supply these goods or services to the opposite party, always take care and always make a point to receive an acknowledgement from the buyer regarding the unequivocal acceptance, like saying that it is unequivocally accepted, like the opposite party do not have any qualms or protest or any sort of disputes from the delivery of your materials or of your services, right? So if you have received this acknowledgement, then the other party would not have anything to say that I do not want to pay you for the services or for the goods of materials that you have supplied to us, because they have unequivocally accepted it, right? They did not issue any issue any concern regarding to quality or quality or the time limit in which such supplies were to be made. So if it is unequivocally accepted and the bills are raised, then the opposite party are liable to pay the amount of the amount which is stated in the bill which is raised by you, right? So it is always necessary to have an unequivocal acceptance from the opposite party and acknowledgement against the supply or delivery of goods and services which is done to that supplier or that buyer. The last is difficulty in realizing payments from buyers, cash transactions, etc. So a lot of times I've seen the MSMEs entering into cash transactions, and the cash transactions is not looked upon, looked down upon in MSMEs businesses, but uh, the cash transactions do not have any trace to prove, right? As we already know that the cash transactions, the transactions made by cash cannot be proved if there is no, if there is no acknowledgement of there, or if there is no acceptance which is received from the opposite party as against those payments. So even if you make cash payments or cash transactions, please keep in mind that you take a receipt or take a note or take an acceptance or an acknowledgement of those cash transactions so it can be proved at a later stage of time. Now, coming to the next slide, the consequential effects due to the challenges, right? As I stated that the it has dominoes effect and cascading effect, right? Because you also incurred a lot of expenses in delivering those goods and services to the buyer, right? And if you do not realize your payments, genuine payments which you have incurred in delivering those goods and services to the opposite parties, then it is a possibility, and it is a high possibility that you'll face consequential effects, like you'll face liquidity crunch, and it would lead to financial lack of financial resources. And then your claims, the, the lack of financial resources, it would hamper your workforce, because the workforce would not be effective, because they won't be getting timely payments, right? Because you have not gotten timely payments. So all the operations of the MSMEs get affected if one bill of the MSMEs is delayed, the payment of one invoice or one bill is delayed, right? So there are consequential effects that the MSMEs face, and there are consequential effects which the MSMEs face if they do not take care of those things which I already discussed in previous slides, which is they would law they would lose out on their claims due to not having enough evidence and materials on record to prove default. Their claims would be undervalued because the recorded transactions would not record the entire transactions. As I already stated, that if you have supplied some goods to one party and you did not have any recorded transactions for it, then let's say if you have supplied a goods for worth 1 crore rupees, and the opposite party have made a payment of 50 lakh rupees, and at one point of time he denies that I won't make any further payment of 50 lakh rupees, then you would be it would be very difficult for you, being an MSME, to prove that the supply of goods that were made by you had the amount of 1 crore rupees attached to it, right? Right, that the opposite party had agreed the amount to be 1 crore rupees for that transaction, because it is not recorded anywhere. In that case, your claim would be undervalued, right? Because the 50 lakh rupees has already been paid, and he would say that I have already made the full payment, then you would not be able to prove that the payment which has been made is not full but is only a part payment. So in cases your claims could be undervalued, you might lose out on claims because certain written transactions would be absent, because you had not communicated or reserved your right to claim liquidated damages, or you have not reserved your rights, or you have not made effective communication stating that the delays which caused the contract to further delay, or the timeline of the contract to get extended, was not attributable to you but to the other party. So in those cases you lose out on claims because it would not be recorded in transactions, right? So you'll have to take this into consideration, because uh, it takes nothing for you to incorporate these things. It takes nothing for an enterprise to streamline their businesses, to conduct their businesses in an effective manner. It might take them a few lakh of rupees by in streamlining their businesses, by getting respective professionals to get the agreements drawn from, to get in touch with CAs, to to effectively manage their statutory filings in GST or income tax, or any other cess for that matter, or they can hire the professional charges of marketing agencies and all of these professionals. And it would take a little amount of professional fee, right, for these enterprises to avail these benefits. But if these benefits are not there, and if these operations and the conducting of businesses are not streamlined, then there are cases and there are possibilities when I have seen enterprises losing out on entire claims because they did not have written transaction, they did not have anything which they could have used to prove that transaction, right? So those things can be really detrimental to you, and uh, those things can be really detrimental, which may cause huge losses to you, which might even lead to the death of your enterprise. So these things should be taken into consideration, and these things should be pertinently incorporated into businesses, so as to effectively manage and operate your businesses, so as to not miss out on these things, on these smaller things, so that you won't be able to realize your genuine amounts from the opposite party, right? Because even if you go to an adjudicating body or a court at a later stage of time, the courts or the adjudicating body uh, rely upon the documents, the documentary evidences, right? They do not rely upon what you have to state without any evidences or documents to prove, right? So it is always necessary and it is always important to have those documents to prove the transactions and the terms and conditions that were agreed between the parties, right? So these things should be taken care of. So I've already stated, the last one is the legal troubles due to ignorance or no knowledge of various industry specific mandatory compliances. So there are a lot of industry specific mandatory compliances that you will have to do, and you do not have any idea of it because you never go and consult a legal professional. Like I'm sure that most of the enterprises who are the attendees in today's webinar have more than 10 employees, right? So if you have more than 10 employees in your enterprise, or on your payroll, then according to Prevention of Sexual Harassment Act at Workplace 2013, you have to have an internal complaints committee. Now it is mandated in law for every enterprises having more than 10 employees to have an ICC of their own. Now what is an ICC? The internal complaints committee is nothing but a committee which has to be constituted as per law, which would receive complaints of sexual harassment at workplace, which can happen at your working place, and they would decide upon those complaints of your enterprise, and they would resolve those complaints, and the annual report of it goes mandatorily to your district magistrate of the respective jurisdiction. Now I know that no one come and asks you to submit these reports, and no one come and asks you if you comply with these conditions or not, but it is there in law, right? So even if, let's say, 5 years from now on, if agency or if the enforcement agencies come to you and they ask you that it is law into 2013 law that you had to do something like this from 2013, but you have not done this as per law, then you would be liable to pay fine, which is 50,000 annually, right? So it is already accruing, and it is the basic legal principle, which the Indian basic legal principle states that ignorance of law is not an excuse. So you cannot say before a court that you did not know a law and you should be excused. So there is no excuse if you do not know the law. So it is always beneficial to you or important to you to go and to consult a legal professional, a good legal professional for that matter, who would let you know the mandatory compliances that you have to go through, right? So a lot of businesses who are dealing in FMCG products, the food products, do not know that they have to comply with a lot of conditions which are there in the FSSAI Act. So there are packaging and labeling conditions. There are if you are a manufacturer of food products, then there are limitations of what should be what chemical should not exceed this percentage limit. So all of these conditions, all of these rules and regulations are present in FSSAI, are present in Drugs and Cosmetics Act. So even if you're dealing with uh, industry specific enterprises, let's say for if you're dealing with manufacturing of e-commerce, right? Or e-waste, right? Like keyboards or some ICs or chips, and things like that, then you have to comply with the e-waste management rules, right? So there are laws which are applicable in every industry specific arenas that you work into, right? That you conduct your businesses into. You just have to have a complete knowledge, a holistic knowledge of all the mandatory compliances that you have to have in order to prevent these fines imposed from prevent these fines to get imposed upon you, and to seamlessly conduct your businesses so that you do not get a so-called notice in the future, uh, calling upon you to explain that why did not you comply with these mandatory provisions which are present in law, and why you should not be penalized for non-compliance. So to prevent these things, I would suggest to always go and to always seek assistance from professionals who are expert in their own areas. So if you have any marketing specific industry, then you should on a daily basis go and consult a marketing agency or someone who knows how to manage brands effectively, or a CA, or a legal professional who would take care of your agreements and mandatory compliances or mandatory filings, statutory filings such as GST, income tax, uh, income tax income tax filings, and all of those things. So I'll move to the next slide now. So the solutions and way forward to overcome challenges. So the solutions and way forward are, as I already stated, there are preventive measures, and then if it is not prevented and the dispute have already arisen, then there are dispute resolution mechanisms. So the preventive measures we already discussed, we already discussed that what all things that can be done by the MSMEs to streamline their businesses, to carry out and to effectively manage and operate their businesses so that they do not face these things in future, where when these disputes actually arise, or when they have to go and to take a recourse under the dispute resolution mechanism. So I'll read it out for you. To enter into a written agreement recording the understanding of terms between the parties, duly executed and properly stamped and notarized. The agreement should be duly executed between the parties. Like the parties should sign those agreements. Even if it is not signed and the terms and conditions of the agreement are complied by both the parties, and the transaction is carried out as per the accordance with the terms and conditions of the agreement, then the sign on those agreements can be done away with. But it is always preferable that you have a duly executed agreement in place and it is properly stamped and notarized. The other one is the work purchase order to be raised under such agreement, that if such agreement is made, it is already made, then the work orders and purchase orders are raised under such agreements, right? The work purchase orders to be shared on an electronic medium too, even if a hard copy of the same is raised. So even if you have given a hard copy of the purchase order or work order to any supplier or any buyer, then it is preferable that you also share a copy of the same on an electronic medium, because at times I've seen the parties denying from having received the physical copy of the of the purchase order or work order. But if you have shared the same document on two other platforms at the same time, then it becomes very difficult for the other party to deny the existence of that document, right? So it is always preferable for you to share it on both the mediums. Like, if you're sharing it, share it in physical copy as well as on mail, recording each and every transactions, its terms, obligations, applicable interest upon delayed payments, consequences of breach, force majeure, indemnity, dispute resolution clause, clause to notify defect or damaged goods and services, rectification period, unequivocal acceptance of work purchase orders if no defect, protest, or demur has been pointed out by the buyer. So as I've already discussed these clauses, I need no I guess there is no substantiation required for me to again discuss these clauses. I'll discuss the clause to notify defect or damaged goods and services and the rectification period clause uh, for your reference. That these clauses you can incorporate in your agreement, saying that even if you point out any defect, or if there is a dispute on the quality of the services or the goods supplied to you, then you can add a clause stating that if you are not satisfied with the quality or the manner in which the goods or services have been delivered to you, then you have to notify us of such inconsistencies, deficiencies which you have found in our goods and services, and you'll have to give us a rectification clause. The rectification clause is a time limit which you extend towards us for us to make right the things which are not accepted to you. So let's say if you have any dispute on the quality or on the on the manner of the delivery of the goods, then you will have to give us the rectification time period for us to go and to rectify those things which are not agreed to you. So in that case, there these things do not go further when dispute occurs, right? So the opposite party do not have a scope to raise a dispute on the quality or on the manner on which the goods and services were delivered to you, because there was a rectification clause, and they had to notify of those defects and deficiencies to you, right? So they do not at that stage, at a very belated stage when we have already reached courts, cannot raise these disputes and cannot raise this concern on the quality of the goods for the first time. So they have to agree as per the accordance of the agreement, that if they are not satisfied with the quality or manner in which the delivery or services of the goods have been made, they have to notify it to the other party, the supplier of those goods and services, that see, these deficiencies have been pointed out by us, you please come and you rectify these things in a given period of time. And if you do rectify these things, then the agreement is unequivocally accepted. Then there is no scope left for the other party to come and dispute on the quality of the services or the quality of the goods. Now we'll come to the other part of it, which is when these disputes have already arisen with the opposite party or opposite parties, then what are all the recourses that are available to MSMEs? So we'll come to the next slide. Yeah. So these are the external solutions. The resolution of disputes, which are litigation, and the other part is alternate dispute resolution. So the first is recourse from MSEFC as per the provisions of MSMED Act. So as I stated, the MSMED Act also in the enactment gives a dispute resolution mechanism to MSMEs, which is only extended to micro and small enterprises. It is not available to medium enterprises and traders of the goods as of now. And the manufacturers and service providers, if they are micro or small enterprises, can go and avail these benefits under the MSMED Act. The MSMED Act has a dispute resolution of its own, which supersedes the Arbitration and Conciliation Act. So I'll come to it later. So the recourse under the MSMED Act is nothing but the recourses which are given under the Arbitration and Conciliation Act. So the resolution of disputes under the MSMED Acts are governed ultimately by the Arbitration and Conciliation Act. So the MSMED does nothing, but it conduct arbitration and conciliation by its own between these parties, and by doing such conciliation and arbitration, it resolves the dispute between the MSMEs and resolve the disputes of the delayed payments. Now, I've gotten questions, and I've already stated in my earlier webinars also that you can come with the claims of liquidated damages and breach of contract to MSMEs, but you should take you should keep in mind that the MSMEs, the jurisdiction of MSMEs in is only restricted for delayed payments, right? So if you have a delayed payment, and upon that delayed payment there are other losses that you want to claim, then you can come to MSME. And if you do not have any delayed payment and you have claims in respect to only breach of contract, then the MSMED Act would not have the requisite jurisdiction to adjudicate your breach of contract claims, right? So all the claims of labor idlement, or the price escalation, or let's say loss of profit, all these claims in isolation cannot be adjudged by the MSMED Act. But if it is coupled with the invoices of delayed payment, then to prevent the multiplicity of proceedings, the MSEFC can get into those claims and can award claims to MSMEs on those claims also, right? So now we'll come to proceedings under Section 138 of Negotiable Instruments Act 1881. So Negotiable Instrument Act, the proceedings under Section 138, as we already know, everyone knows that it is the proceedings for dishonor of checks, right? So I've seen a lot of enterprises, what they do is to safeguard their interest and to safeguard, to prevent the issues of delayed payment, what they do is ask the buyer, or buyer of the goods, or the buyer of the services which is supplied by them, to give them a post dated check, which would be dated after the extended credit period expires. So let's say in your invoice you have given 30 days time period for for a buyer to make payment to you, right? And if you have raised an invoice on 5th of August, and the time limit for making payment is 30 days, then for 30 days, till 5 of September, till 5th of September, you cannot go to the court, or you cannot go to any tribunal for asking those payments, because you have already given him a 30 days time limit to make payment to you, right? So what they do is they ask a check from the opposite party of the same amount of the bill that they have generated to the other party after the 5th of September, right? So when the credit period expires, so let's say the 30 days expires on 5th September, they ask the opposite party to give them a check of 6th September, right? So as soon as the credit period expires and they have not made the payment within the 30 days, now you have a post dated check in your hand of 6th September, that you can go to the bank, and you can tender that check, right? So in this case, two things might happen. The first thing, that you might get the payment. If you get the payment, then it is well and good that you have received the payment on the 31st day. Then it is fine, you have nothing to worry about. And if you do not get the payment, the check is dishonored, then you receive a memo from the bank, right? A memo from the bank gives you a memo, an acknowledgement saying that the check number this and this, issued by this and payable to this party, has been dishonored due to this reason. And the reason might be anything, be it insufficiency of funds, or be it on any other account. If it is dishonored, then you have recourse under Section 138 of Negotiable Instrument Act to simultaneously have civil actions as well as criminal actions against the party who have issued that check to you, right? So the second option is this. The third option is Insolvency and Bankruptcy Code. So the Insolvency and Bankruptcy Code, the MSMEs are generally covered under the operational creditor definition, right? Because I do not think a lot of financial institutions get themselves registered under the MSME Act, right? And anyway, they would have to be registered in the NBFCs and banking regulations other than the MSMED Act. So the most of the creditors under the MSMED Act, the most of the enterprises are covered under the operational creditor definition, which is provided under the Insolvency and Bankruptcy Code. So, what are operational creditor? The operational creditor are all those creditors who have extended some services or goods to the party, or which or who have contributed in the operations of a company. Like if you have given financial assistance to a company, then you are a financial creditor. If you have provided money, loan, financial assistance of any kind, if you are a guarantor to any loan agreement, then you are a financial creditor. And if you have supplied any goods, services from which the payments are due, then you are covered under the definition of operational creditor. So the Insolvency and Bankruptcy Code, being an operational creditor, you can approach the Insolvency and Bankruptcy Code, the National Company Law Tribunal, uh, under the Insolvency and Bankruptcy Code, to initiate the corporate insolvency resolution process of the corporate debtor who is in debt to you. Now, there are certain qualifying conditions to maintain an application under the Insolvency and Bankruptcy Code. The first is that your dues should be above 1 crore of rupees. So if you have 1 crore of rupees and it is defaulted, it is due to a company, then you have to raise a notice in section 8 of the Insolvency and Bankruptcy Code under form B. After raising that notice and after giving 10 days of time to the other party to raise any dispute, or to raise or to make payment, and if any of those things are not made by the opposite party, then you can approach the National Company Law Tribunal for initiating the CIRP against the corporate debtor. The other one is alternate dispute resolution, is the Arbitration and Conciliation Act. So as you have seen that if you're an MSME and you have entered into an agreement uh, at, let's say, in 2015, and you got yourself registered as an MSME in 2020, and so it is already decided and well settled by the Supreme Court in 2022 that if your registration and the invoices that you have raised upon the opposite party is of the prior date from which you have obtained from the date on which you have obtained your registration for MSME, then your dispute won't be resolved under the ambit of MSMEs. So the MSME would not have jurisdiction to adjudicate upon your issue. So for the MSME to have the jurisdiction, you have to have a registration first, and the agreement and the invoices after that registration. Then only those invoices and those purchase orders can be brought under the ambit of the jurisdiction of MSEFC, that is MSME Samadhan. So in those cases, when you have an agreement of prior date on which you have obtained the registrations, then you cannot go to the MSME Samadhan, right? Because they do not have the jurisdiction to adjudicate upon your disputes. Then you have to have a dispute resolution clause. You'll have to look under your agreement as to if there is any arbitration and conciliation clause, dispute resolution clause, which states that you'll have to conduct conciliation, and if it fails, you'll have to conduct arbitration, and by only arbitration you can resolve your disputes, and the jurisdiction of Mumbai, or let's say Delhi, uh, would apply, and it would be governed by Arbitration and Conciliation Act 1996 of India. Then the alternate dispute resolution, the Arbitration and Conciliation Act comes into play, and your disputes would be governed by the Arbitration and Conciliation Act. The next one is civil suit for recovery of money and summary judgments. So the civil suit for recovery of money would be applicable when you do not have arbitration clause also in your purchase order, and there are no agreements as to direct to the parties that this would be the dispute resolution mechanism. So if there is no clause directing the parties that this would be the dispute resolution mechanism that you'll have to opt for, then then the classic method for obtaining for obtaining your delayed payment or recovering your payment from the other parties would come into play. That is the civil suit for recovery of money, or civil suit for recovery, right? And the one part of civil suit of recovery is summary suits and summary judgments, right? We'll discuss these things. So there are, we'll come to MSMED Act. We'll discuss some of the provisions and how can a reference of a dispute be made to MSEFC. So the section 7 states the classification of enterprises, which we have already decided, right? On the in the first slide, we already decided that what are the qualifying conditions for an enterprise to get itself registered into micro, small, or medium enterprise, right? So section 9 provides for measures for promotion and development. It states that the central government might issue might come out with specific schemes, policies, and facilitation facilitation policies or schemes for the development and promotion of MSMEs, right? The section 9 deals with those kind of schemes and policies that can central government can come out with for the promotion and development of MSMEs. The section 10 is credit facilities. So the credit facilities which the central government might extend to MSMEs, right? The credit facilities, the rebate on the credit facilities that the MSME get, right? The MSME, the rate, the the rate on which the MSME can get loans from the public sector banks are generally less than the other enterprises, right? So if you are registered under MSME or are registered as a micro, small, medium enterprises, the interest rate of your loan amount would be less than the other enterprises on which they have obtained that loan, right? So those are covered under the credit facilities provision. So section 11 is procurement preference policy. So you must have seen that the MSMEs are given preference policy in government tenders also. The government tenders give the MSMEs a bit of preference as against the other enterprises, like even for some what percentage, if the MSMEs are not even the lowest buyer, lowest bidder, and the enterprise which is not an MSME happens to be a lowest bidder, then the preference is given to MSME even if it is not a lowest bidder, and the tender is awarded to the MSME, rather than it should have been gone to the other enterprise who was the lowest bidder. But just because of this procurement preference policy, the the tender is ultimately awarded to the MSMEs, right? And it is generally done only up to an extent of percentage. It is not like that even if the other enterprise is the lowest bidder and the MSME is quoting far more high value, even then the MSME would get the tender, right? The accommodation is given only up to an extent of percentage. So within that percentage, if MSME's bid falls, then as per the procurement policy, the even if it is not the lowest bidder, the tender is awarded to the MSMEs, right? So that is the procurement preference policy. The section 12 is the appropriation of funds, how the funds should be appropriated for promotion and development of MSMEs, and so forth and so on. So the section 12 deals with the funds, and section 13 is grants by the central governments. So it deals with the central government and the grants that can central government can come up with in a respective financial year. The section 14 is administration and utilization of funds. Section 15 is liability of buyer to make payments. So now from here on, the dispute resolution mechanism starts. So how the MSME deals with the dispute referred to it starts from section 15. I'll give you a brief understanding. I'll give you a brief understanding of it. So the section 15 states the liability of buyer to make payments. So the section 15 states the buyer would be liable to make payment after the 45 days from which from the date on which the supply or the services were rendered to that buyer, right? So it limits the credit facility, the credit limit, to 45 days. So section 15 states that after 45 days the buyer would be liable to make the payment to the supplier. Section 16 states date from which and rate at which the interest is payable. So from 46th day, the interest which would be payable by the buyer on the delayed payment would be three times. So three times of the bank rate notified by the RBI. So there is a bank rate which the RBI notifies, which is for every other bank to to extend to extend loan facilities to the customers. So that notified rate, three times into that notified rate, would be the liability on the buyer to make payment. So that much of interest would be liable on the buyer from the 46th day till the realization, till the payment of those amount which is due from those buyer, right? So from the 46th day, as I stated, that the interest rate would be compounded monthly, and it would be three times as is notified by the Reserve Bank of India, right? So section 18 is reference to MSEFC. So reference to MSEFC states that if any supplier has any issues relating to delayed payment, so it covers any issues relating to delayed payment. So any issues covers also ancillary issues which can contribute to delay in payments, right? So any issues which pertains to delay in payments can be referred in under this section to MSEFC of a respective jurisdiction. So let's say an enterprise is registered as an MSME in Madhya Pradesh, then it is entitled to make a reference under section 18 to the MSEFC Bhopal or MSEFC Madhya Pradesh in any other jurisdiction of, let's say, if it is in Jabalpur, then the MSEFC Jabalpur would have jurisdiction, like that. So it is entitled to make the reference under this section 18 to MSEFC that, see, this invoice is still unpaid, this much of amount is still unpaid, and this much of amount has been arising from this PO. You have to upload the PO, the invoices that are in question, and you have to write all the details of the opposite party, all the details of you, and you have to make a reference to the MSEFC. You can make it online or you can make it offline. After you make a reference, the MSEFC receives your documents. They go through your documents. They conduct a preliminary examination. Uh, they go through the documents preliminary, and after they are satisfied with the veracity and the genuineness of the document, and if they see that they have enough jurisdiction to deal with the matter, they convert the case. After converting the case, they issue a notice to the opposite party to make the payment of the disputed amount of the delayed payment, and they give 30 days time period to the opposite party to make payment. Now the opposite party have two options. Either it can make payment of the delayed payment to the opposite party, to the supplier, or it can furnish a reply to the MSCFC saying that he is not liable to make this payment, or he has made this payment, or this delayed payment is not applicable to it, or he is not liable to pay these amount to the supplier. Then the MSCFC, what it would do, it would take that reply from the opposite party, and it would again furnish those reply as received from the opposite party to the petitioner, that is you, and it would ask that if you have any rejoinder reply to it. So you will have to submit a rejoinder reply saying, no, our this claim is genuine claim, we have all the documents to support it, and this amount is the opposite party is liable to pay this much of amount to the enterprise. Then the MSME, what it would do, it would conduct a conciliation, and it would invite both the parties to sit and to amicably resolve the disputes. And if it is resolved, then well and good, it would draw a award as per the terms and conditions agreed between the parties, as per the one time settlement agreed between the parties, and it would be enforced. And if it is not settled between the parties, then it would the both the parties would be referred to an independent arbitrator. It might be an independent arbitral tribunal, or a single arbitrator, or three arbitrator, or five arbitrator, or any quorum of arbitrator in odd numbers, right? So it can be referred into arbitrator, after which the arbitrator hears both the parties, considers all the documents placed on record, considers all the evidences, and then accordingly passes an award. And that award is binding on both the parties, right? That award has decisive value, and it has to be enforced after that. So these are the provisions which uh, deals with the resolution of disputes under the MSMED Act. Now I'll come to the other uh, recourse, which is dishonoring of checks. As I already stated, the section 138 deals with dishonor of checks for the reason of insufficient funds or on any other accounts. The section 139 gives the presumption in the favor of the holder. So section 139 states that the check holder, it has the presumption that whoever has given the check to anybody has provided the check in discharging or in furtherance of discharging any liability or any debt, right? So it has the preliminary presumption in the favor of the check holder that the check has been given to him in furtherance of discharging any liability. The section 142 speaks of the cognizance of offense. The cognizance of offense can be taken by a metropolitan magistrate or judicial magistrate of first class. And I already stated the procedure that as soon as the check gets dishonored, you get a memo from the bank stating the reason why the check has been dishonored and what check has been dishonored, the check number, the party's name would be there. Within 10 days from receiving that memo from the bank, you have to issue a notice to the opposite party saying that your check has been dishonored, and you demand a payment of the same amount as was stated in the check. And if in the 30 days, if from issuing notice, from date of issuing notice, after 30 days the payment has not been made, the holder of the check is at liberty to initiate civil actions as well as simultaneously criminal actions against the signatory of the check. Now it that might be the enterprise as a separate identity and the director of that enterprise too. Now, the recourse under insolvency and bankruptcy code. So, as I already stated, that you'll be the operational creditor and you'll have to maintain an application under Section 9 of the IBC against the companies. And the IBC can only be done against a company and LLP. So, if the other party happens to be a government, a department, or a company which is a government company, because the government companies are exempted under the IBC regime, that they are not, they cannot be taken under the IBC Act, right? So if it happens to be a government organization, a government company, or a government department or a trust or a society, then you cannot avail the dispute resolution benefit of IBC. It can only be availed when it is a company, a limited company, a public limited company, or a private limited company, or an LLP. And the debt has to be above 1 crore of rupees, right? For you to come under the IBC and for you to avail the recourse under IBC, right? The section 5 clause 21 defines operational creditor. As I already stated, that anyone who supplies goods or services to the company, or an employee of a company, anyone who contributes to the daily operation of company is an operational creditor. And there are only two creditors under the IBC, which are financial creditor and operational creditor. However, there are other creditors as secured creditors and unsecured creditors, but there are general definitions. But only two kind of creditors can maintain an application under the under the IBC Act, that is financial creditor and operational creditor. So section 8, as I already stated, that you have to issue a demand notice first to the corporate debtor saying that this is my demand, this is the disputed amount that you have to pay, and this is defaulted by you, and this much of amount has to be paid along with all the supporting documents. And it is issued under form B. So if you'll go to IBBI, Insolvency Bankruptcy Board of India, its website, you'll find a form B. So a form B under the IBC Act, if you'll even open the IBC Act, you'll find form B uh, uh, on the last part of the IBC, right, where all the pro formas are listed. So in form B, as per the particulars of Form B, you'll have to fill out the details and you'll have to issue that Form B to the corporate debtor demanding the payment. And if it is not made within 10 days from issuing that demand notice, you'll be eligible to make an application under Section 9 for corporate insolvency resolution process of those corporate debtor. Now, there are something which has to be kept in mind, because I've met with some of my clients who ask me that they specifically want to pursue their disputes under insolvency and bankruptcy code just for this mere reason that they want to cast enough pressure on the opposite party. So that is a practical thing to do so, and that is very understandable also, that the parties want to go to IBC, the parties want to avail the recourses under IBC, but you have to have the qualifying conditions to go for IBC, right? So the first and foremost condition is that the amount that you take to IBC, that the amount that you raise as a demand in IBC proceedings should not be a disputed amount. It should be a crystallized amount. So any amount which is disputed by the opposite party, so let's say you issued a notice to the opposite party in Form B that I have to have 4 crores of rupees payment, 4 crores of payment due from you, right? From I have to get 4 crores of payment to you from you, right? Then the 4 crores of payment should be crystallized. It should not be disputed in any manner, right? So if it is disputed, then the NCLT would redirect you to get the amount crystallized first, then only you can come to the ambits of IBC for initiating the CIRP, right? So if your disputes or if your default and debt amount is not crystallized, is not acknowledged or accepted by the other party or the opposite party, or it is reflected in the accounts of opposite party also that it has to pay more than 1 crore rupees to you, in that cases you can come to IBC, and in those cases it would in actual create enough pressure on the opposite party or the corporate debtor as to the apprehension that they would lose out on their company, because what IBC does is that it replaces the management of the company. IBC is not a recovery mechanism per se, but what it does is it replaces it just terminates the entire management of the company, and it replaces the company from other management. Now it believes that the management who was not able to pay its creditors on time was not effectively managing the company, and the management should not be allowed further to manage the company, and that company is in a way by the process of law is floated in the market for the other companies or other individuals to buy or to make offer for, and when they make offer uh, to the committee of creditors accept those offers and the resolution plan goes through. Then you might ask, what are the committee of creditors? The committee of creditors are the committee of financial creditors. You have to get this in mind that the operational creditor do not form the part of committee of creditors, and the committee of creditors is the only body which decides whether a resolution plan should be accepted or not, whether a plan whether a resolution plan given by any other party which states that I will resolve your disputes, I will pay your defaulted amount in these manner. If it is accepted by the COC, then it becomes a contract between the company and the successful resolution applicant, right? And then the resolution would be done on those accepted terms and conditions. So this proceedings are very important as far as recovery are concerned, because if even if you have initiated proceedings under any act for that matter, so be it MSMED Act or Arbitration and Conciliation Act, if any party comes to IBC and is successful in getting the CIRP initiated of any company or any corporate debtor, all the other proceedings in any other law ceases and freezes for the time being till the resolution of IBC, till the process of IBC is completed. So the IBC has an overriding effect on all the other laws. The MSME Act has an overriding effect upon Arbitration and Conciliation Act. Arbitration and Conciliation Act is enacted in 1996, the MSMED Act in 2006, and the IBC in 2016. So all these three acts have 10 years gap in them. So 1996 Arbitration Act does Arbitration Act and 2006 MSMED Act. So the 2006 MSMED Act has an overriding provision which states that it would override all the other laws which were present at that time. So it would naturally override the provisions of Arbitration and Conciliation Act because it was enacted in 1996 and MSMED Act in 2006. In the same manner, the IBC Act also has an overriding provision. So now the IBC Act is enacted in 2016. So the overriding provision of IBC overrides the overriding provisions of MSME, and it overrides all the provision of any other act, right? So when the proceedings in IBC gets initiated, then all the other proceedings get freezed. All the other proceeding goes into moratorium, right? So this proceedings is given the most preference in all of these provisions if taken together, but it is not as beneficial to operational creditor as it is to financial creditors, right? So these things should be kept in mind, right? The section 33 is initiation of liquidation. So in case the resolution of the corporate insolvency resolution process of any corporate debtor is not successful, then the corporate debtor goes into liquidation, and after liquidation, whatever proceeds that it generates, it is divided as per the provision of section 53, which is waterfall mechanism, which gives the preference of how the proceeds should be distributed, uh, how the proceeds amongst the creditors should be distributed. So section 53 takes care of that, right? So all of these things I already discussed, right? So the realization of amount due is not guaranteed based on the resolution plan, if any distribution of proceeds as per waterfall mechanism. So for operational creditors, it is not in guarantee that if you had 1 crore of debt, you would, after successful resolution application or even the IBC proceedings goes successful, receive the same amount of 1 crore or the 1 crore with applicable interest, but it depends on the committee of creditors and the resolution plan, which is being approved by the committee of creditors, which decides how the proceeds would be distributed. Now, we'll come to the simple arbitration, which also would be applicable for the arbitration in MSME. So, section 9 is interim measures, etc., by courts. So, before arbitral tribunal is constituted, and if you wanted any interim measures from if you want any interim measures, and there is some time for the constitution of arbitral tribunal, the arbitral tribunal is still not constituted, then you can approach the court under section 9 of Arbitration and Conciliation Act for interim measures till the time the constitution of arbitral tribunal is not happened. The section 11 is appointment of arbitrators. So I've this has to be kept in mind that I've seen in a lot of contracts, in a lot of agreements, that the dispute resolution mechanism encapsulate a clause which states that the sole arbitrator would be appointed by him or would be his officer, and he would be the sole officer to decide and to adjudicate the claim of the parties which would arise from the purchase order or any agreement. So that is not enforceable by the court. In 2019, the court has already stated that the arbitrator has to be appointed by the both parties mutually, and one party cannot solely by its own accord can appoint an arbitrator. So if your clause does have that provision which states that the one party officer would be the sole arbitrator, then you can file an application under section 11 for appointment of arbitrator, and the court would appoint a neutral arbitrator for adjudication of disputes. The section 16 is competence of arbitral tribunal to rule on its own jurisdiction. So any jurisdictional issue, like the issues of limitation, the issues of limitations are not jurisdictional issues in Arbitration and Conciliation Act. I'm really sorry. So the jurisdictional issues, whether the arbitral tribunal has the jurisdiction to hear the disputes, or the disputes are arbitrable or not. So all these things the court have held, and the section 16 in Arbitration and Conciliation Act states that the arbitration tribunal itself is competent enough to rule on its own jurisdiction. So even if you state to arbitral tribunal that you are not qualified enough, or you are not uh, eligible enough to decide upon these matters, it is upon his own competence that he would decide those issues, that whether he is competent enough to take upon those issues, or whether he is not competent enough to take upon those issues. So these issues cannot have to be do not have to be taken into court separately. So for preventing multiplicity of proceedings, the competence of arbitral tribunal is affirmed, right? In section 34 is the application for setting aside an arbitral award. It is very limited in nature. There are very limited grounds upon which you can challenge an arbitral award. And the arbitral award, the provisions for arbitral awards are governed under section 34. So even if we discuss the basics of section 34, section 34 in itself is so huge, and the jurisprudence of section 34 is so huge, that it would take another one or 1.5 hours to effectively deal with this provision, right? So just keep in mind that the section 34, under section 34, you challenge the award of an arbitral tribunal, be it passed by MSEFC or by an arbitral tribunal, right? The conciliation is governed under section 61 to 81 of Arbitration and Conciliation Act. The filing of claims. So, as I stated, how the Arbitration and Conciliation Act, the proceedings of Arbitration and Conciliation Act goes. So, it depends on the procedural order. It depends on how the arbitral tribunal wants the proceedings to go, or how the parties wants the proceedings to go. But generally, the claimant has to file a statement of claim, uh, uh, by giving a brief or giving a detail of all the claims and how that claim came to be. And all the claims have to be crystallized, and the grounds for claiming those amount should be also mentioned. And the opposite party then file their statement of defense, filing the opposite arguments that why they think that they should not give these claims to the claimant, and what grounds do they have to think that they are not eligible, they are not liable to make payments. And after arguments, and after producing all the documents to the arbitrator considers the statement of claim, the contents thereunder, and the documents and evidentiary values which are placed on record. And after hearing the submissions made by both the parties, accordingly it passes an award, and that award can be enforced as per the provisions of CPC under the enforcement provisions. And yeah, it can be enforced, and that's how the arbitration proceedings comes to an end. So seat, venue, and jurisdiction, these things are to be taken care of while drafting an agreement, while drafting an arbitration clause. So where should be the seat, where should be the venue, and what should be the jurisdiction? So the seat is where the arbitration proceedings should be conducted, or where or or which which jurisdiction, which arbitration act would govern the arbitration proceedings, right? It would be given under the seat. The venue is only the place at where the arbitration proceeding should be conducted. It might be someone's office, it might be a seminar hall. So it only is a physical place where the arbitration proceeding has to be conducted. The jurisdiction is the jurisdiction of the courts that would have the oversight power over the arbitration and conciliation. So let's say if the seat of arbitration is in Bombay and the jurisdiction is in Bombay, the High Court of Bombay and the courts of Bombay would have the jurisdiction. So you'll have to fix a jurisdiction whenever you're drafting an arbitration agreement, or an arbitration clause. Coming to next, this is the last way of recovering the amount, which is civil suit for recovery, civil procedure code, in which order 4 you can institute a suit on. And the suit is nothing but you'll have to just write a story that how the claim came to be, what are the claims, uh, what are the relied documents that you want to produce. And it goes on like normal suit, right? You file a suit, the opposite party would file a written statement, then you would file your rejoinder reply, after which the both parties would come for an argument, the court would hear the arguments, and after which a decision would be made. The same is Order 37, which is summary suits. Now, summary suits are nothing but is a different class of suits under which the opposite party are not given the scope to come and defend the suit. So if in summary suit you file a summary suit, the opposite party are given a notice which states that a summary suit is filed, and the opposite parties are called upon that why should they be given a defense, why should they be given a chance to defend themselves, because summary suits are nothing but if you have a claim which is well documented and which has no disputes at all, then you do not have to follow the general procedure of suits. You can come into summary suits under which the opposite parties are not given the opportunity to defend themselves, and on that first notice, if they come and they appear to the court, and if they satisfy the court that right opportunity to defend is provided to them, then your summary suit would be converted into normal suit. And if they are not able to satisfy the judge that why an opportunity to defend should be granted to them, then they would not be given an opportunity to defend, and the court would basis on the suit and the material produced by us would give a decision to would give a decision, and it would not require the other party or to hear the other party, right? The jurisdiction as per the civil CPC is as per section 18. The jurisdiction can be at the where the defendant resides, like where the opposite party resides, or where the cause of action arose. So the cause of action is a very subjective issue, and it has to be decided on case to case basis, and to determine whether what all places are there where the cause of action has arisen, right? So it's done. And the last tips and suggestions are: always mention applicable GSTIN, UN, PAN numbers on invoice, registered office with address of both buyers and MSMEs, amount, payment terms, interest applicable, correspondences. So all these things which I already stated are incorporated under quick tips and suggestions. Just keep in mind that your MSCFC registered number, GSTIN, UN are all reflected. Your registered office address is reflected on your invoices. So that's it. I'll wind up my webinar for today.
सर
And
काफी
we'll take
सर थैंक यू सो मच
this.
सर, काफी अच्छा वेबिनार रहा, और सर
Thank you.
काफी
Thank you so much.
पार्टिसिपेंट्स के क्वेश्चंस भी हैं।
Thank you so much.
आप
Thank you.
देख पा रहे हैं सर Q&A?
Yeah. I'll
Yes,
switch on my
please.
video. I'll switch on my video. I'll just read the questions for you. Just a second. So, sir, how can we recover our delayed payments if the party is insolvent, died, or has shifted to some other place? Okay. So, I would first ask, who is this? Who has asked this question? Poonam Kayar. Hello, Poonam. Are you there?
सर मैं कनेक्ट कर लेती हूँ, एक सेकेंड। सर शायद वो चले गए हैं। सर नेक्स्ट क्वेश्चन ले सकते हैं हम?
Okay, no problem. We can take live questions if possible. Yeah.
गायत्री जी, आपका क्वेश्चन सर से आप पूछ सकते हैं। सर Q&A बॉक्स में काफी सारे क्वेश्चंस हैं, और मैं सभी पार्टिसिपेंट से रिक्वेस्ट करना चाहूंगी कि आप अपने हैंड रेज कर लीजिए ताकि मैं कनेक्ट कर सकूं। उमेश जी, आप अपना क्वेश्चन पूछ सकते हैं सर से।
Q&A. Okay.
Yeah. Hello. Hello.
have not received payment from.
सर आपकी वॉइस ब्रेक हो रही है.
Okay, I just saw the read out the questions now. Question from, yeah. Hello.
Yes. Yeah. Hello. See,
Hello.
yeah. So I have filed with MACFC for a dispute,
Okay.
or say for no payment from a government organization, like if I have to say MMRDA. Okay. And the problem is that
Okay.
our work order was much before even the MSMED Act.
MSME registration.
That was the MSMED
Okay.
Act came in 2006, right? So
Yeah.
our
Yeah.
work order was dated in 2004, but actually
Okay.
the payment was denied only recently. That was in
Okay. So the
2021.
invoices were after the post the registration. So the
Invoices were
invoices.
uh, invoices were before my MSMED registration.
Okay. Okay.
Invoices were uh, before my MSMED registration. But if you, as you have just
Okay.
mentioned, our contract
Yeah.
talked about arbitration through their own officers. Okay. So,
Okay.
which also was
Okay.
never conducted. And in 2021, okay, they sort of had
Yeah.
a mock kind of arbitration, I would say. And then they said, ki, okay, we
Yeah.
cannot make the payment. So the denial or the refusal to pay came in 2021. And our MSME registration was 2016. So,
Okay.
so I'll
Okay.
again put it in proper
So so
perspective.
so
Yeah.
so have you already gotten an award from MSCFC?
No, no, no. But I have already gone
You have
through.
not, right? Because the MSCFC would not have jurisdiction to to
But
to decide upon the invoices and the claim amount. Like I would ask certain questions from you. What is the unpaid invoice date?
uh, 2012,
2012,
the
and you
last
have
one.
taken your
And
registration.
yeah, to
Yeah, so you
2016.
raised an invoice. Okay, you raised an invoice in 2016.
No.
Hello. So you have taken a registration in 2016, but
Yes.
the invoice which been unpaid by the MMRDA is of which date?
Invoice was 2012.
2012. Okay. So invoice was 2012, and after which they have not made any payments or they have not acknowledged also.
Acknowledged that they have to pay us, no. Uh, but in 2021, they had an
Okay.
internal writings in which one of the officers
Okay.
had said it that this payment is due. After which they conducted a hearing, in their internal hearing, wherein we were called, and that is when they refused to pay us. That was in 2021. So the refusal came
Okay.
in 2021.
Okay. So I'll have to go through the award that they have given you, or the refusal that they have given you,
Okay, okay.
because in my opinion, sir, I'll let you know that if it is of 2012, the invoice is of 2012, it is already barred by limitation. The limitation is of 3 years. Now there are two options. If they have uh, written an acknowledgement, or have accepted that they have a due in 2021, then it can be said, and the limitation issue can be prevented by saying that the promise to pay a time barred debt makes a fresh consideration and makes a fresh contract, right? Then you are eligible now to again pursue that claim, but your recourse would not be before MSMED Act. It cannot be before MSMED Act. You'll have to go through arbitration conciliation if it is there, if it has dispute resolution clause, your agreement. And if it is not there, if dispute resolution clause is absent in your agreement, then you'll have to go to the city civil court. of your respective jurisdiction, the commercial court of your
In
respective
fact,
jurisdiction.
in fact, I have
सर सॉरी टू इंटरप्ट यू सर, आपकी जो भी क्वेश्चन है आफ्टर वेबिनार हम सर से कनेक्ट कर देंगे, और काफी पार्टिसिपेंट्स के क्वेश्चंस
problem.
आ रहे हैं.
No problem. Even if I get his
Sure,
phone number, I can talk
sure,
to him.
Umesh ji. We'll talk on call. And after going through your document, I'll be at a better position to understand your dispute in a much effective manner. So I'll drop my email ID here. What you can do is to you can forward you can forward the email to me, or Richa will drop my email ID here.
शांतनु जी, आप प्लीज अपना क्वेश्चन पूछ सकते हैं सर से.
Hello.
Yes.
Hello.
Shantanu,
Am I audible?
Yes, sir.
Yeah. You're audible.
Hello, Pratik ji. So my question is,
Hi.
we have supplied services. We are a drilling company, and we are under contractual obligation with another PSU. And the PSU, we completed this work already. We started it in 2020, and it was post-COVID time. And even during COVID, the work was ongoing. And 2020, we suffered huge losses. And after that, even till date, our payment is pending. And we have sent them almost 10 notices. And ये जो 10 notices दिए हैं, इसमें हमने insolvency and bankruptcy का भी बताया है, उनसे demand notice भी कहा है. I don't know if I can share my screen. अगर मैं कर पाता तो I would show you the exact letter that I have.
No. What you can do is you can provide me all the documents. I will go through the documents. It is not a problem for me. It's my work. I'll go through the documents. I'll advise you accordingly. That is not a problem. First, I'll ask you some questions. That it is already acknowledged by the PSU that they have to pay you this much of amount, or it is disputed.
No, so there is no acknowledgement,
they have agreed.
no response. There is no response from them regarding delayed payment. And we have been writing, the work is completed since more than a year ago. And the PSU was responsible to supply these services to another government agency. So, and the PSU was
Which PSU
party
is this?
Webcos.
Okay. So which PSU is this?
This is Webcos, WAPCOS. And it was working, yes. And the PSU was supposed to provide these services and get the work done for a government Ministry of Jal Shakti, government body. So they conducted tendering process, and I got the tender, and we drilled these wells. These are water wells for them. And so the work has been completed since more than a year ago, and till date they have not issued me work completion certificate, and they have not made me payments. More than 1 crore rupees is pending till date, and I have given them more than 5 to 8 notices, and regarding notice under MSME section so and so with insolvency and bankruptcy. And also I have furnished various circulars of Ministry of Jal Shakti wherein they are asking MSME to be paid timely, so that to support them during these hard times of COVID in 2020, because that I got that completely. Yes,
I got that completely. So so the Webcos is which government's instrumentality, if you can tell me?
They are an independent PSU, public sector undertaking company, which is a mini Ratan PSU company.
It is a mini Ratna. Okay.
Yes.
I have not heard of Webcos before. That is why I was asking. No problem. So Shantanu, first things first, the IBC specifically excludes the government companies from its ambit, right? The second part of IBC excludes the government companies, the government instrumentalities from its ambit, which means that you cannot take government companies into insolvency, right? However, the Supreme Court, while deciding the Competition Commission case as against the Coal India Limited, have already stated that have given a adverse opinion as to why the government companies should be exempted or excluded from these provisions. That is a very different issue. We can go and we can
No,
wait
no.
for
So
IBC
my problem
proceeding.
my problem is
Yeah,
not with respect to insolvency proceedings,
you
but my
just want
problem
your
is
salary, right?
because of the payment. I am on the verge of insolvency. I have no other, my whole liquidity, as you mentioned in the presentation. So I am
Yeah,
suffering
yeah,
huge
yeah.
losses with respect to my liquidity crunch, and I have no working capital available.
I
I'm not
completely
able to take
understand,
any other
Shantanu.
contract. That is what I've put them in email and writing, and I've actually calculated
Okay.
invoice wise 3 times of bank rate and then putting it into days, and it starts right after 45th day. So it starts from 46th
Yeah,
day or 42nd day, whatever is
yeah,
the rule. I have created
yeah, yeah.
that sheet and shared with them as well, along with
Okay,
my
okay.
notices. I have all the
So
documentary proof. I would want that if you could just, in a brief manner of time, if you could tell me how do I proceed with filing the complaint on MSME Samadhan?
I'll tell you right away. I'll tell you right away, Shantanu. What you do is go and you refer your agreement, whatever agreement they had with you. I am sure that they must have given you an agreement because it's a mini Ratna company. They always
Yes,
enter into an agreement with the parties. You
yes,
will find a dispute resolution clause there. So in the agreement, you will find a dispute resolution clause. It might say that the both the parties would mutually agree to appoint an arbitrator, or it would say that my officer would be the sole arbitrator. So if it says that their officer would be the sole arbitrator, what you do is you file a section 11 application in the respective high court, wherever the dispute resolution mechanism or wherever the dispute resolution clause gives them the jurisdiction. It can
yeah.
give it to
That is
Delhi or it can give it to
it is New
Bombay.
Delhi. It is New
It
Delhi or
is New
Gurgaon,
Delhi. So
probably.
yeah.
Yes,
Okay. So your section 11 application is Gurgaon would lie in Punjab and Haryana High Court if it is Gurgaon. If it is in New Delhi, it will lie it in Delhi High Court. That is if you do arbitration. If you do arbitration, you would be able to claim all the claims that you can think of, right? Like labor idlement or the cascading effect or the losses that you have suffered due to delayed payments. But if you go to MSME, then your claim would be restricted in a manner that you'll have to start from the invoices which are delayed. So the basis of MSME's jurisdiction is delayed payment. So if you have invoices which are delayed, the MSMEs would conduct the arbitration and would award the invoice amount to you. But they do not generally go into computing the breach of contract losses, or they do not go into computing loss of profit or loss of opportunity losses. uh,
no
I have
problem.
not
I
seen
got it.
them doing.
Even
Yeah, yeah.
so, my interest with respect to delayed payment with respect to MSME is amounting to somewhere around 35 lakhs or 36 lakhs as per my calculation, with the kind of
Yeah,
invoices
so
that have been delayed.
your invoice amount and the applicable interest, which is 3 times the rate notified by the RBI, that you can claim
Yes.
before the MSME. But for all the other claim, and including these unpaid invoice and the interest amount, all of these can be asked by you in arbitration. So if you do arbitration, you can do all of this in one proceeding. If you also do arbitration and MSME, then you'll have to go for the invoice amount to claim the invoice amount to MSME, and for the all the other amount you'll have to invoke the arbitration. So it is your
And
commercial wisdom.
these two
If you
would go
want to,
parallelly.
yeah,
If
it
I
can
go
go
for both.
parallelly, yes.
Okay.
Yeah,
So
it
section
can
11
go
is
parallelly,
under,
but then it is not preferable, Shantanu, because why would you conduct two proceedings for one dispute, right? If you do
yes.
arbitration, just arbitration, you can claim everything, including your delayed invoice and everything in arbitration. You do not have to do MSEFC in every cases. MSEFC are
Okay.
those cases when your delayed payment are stuck, your invoice payment are stuck. So you just make a reference the MSME would see that you have generated an invoice, they have not issued any protest or demur on the quality of services or the quality of goods, then they would pass an award saying that you will have to pay the invoice amount as per the applicable interest. That's it. That's where the jurisdiction of MSEFC stops. But the arbitration tribunal would be the apt tribunal for you to recover your disputes, because it would have the jurisdiction to entertain all of the components. Yeah.
Okay. Pratik ji, could you mention the section and under what Act Section 11 under Arbitration and Reconciliation Act, or what is Section 11
Section
talks
11
about?
clause 6. Section 11 6 of arbitration and conciliation. I'm just typing it.
Okay. So I go to like I have my lawyer file the case in High Court. Basically, I sue them in this case.
Yeah.
And I put all my documents and create my case and file it in the prevailing High Court as per the tender document, the contract document.
Exactly.
Okay. Do I need to serve them a legal notice before doing this, or is my the letter email I have shared that has my official letterhead and that
You
has a
have to
demand
serve
notice
a
already?
legal notice. No. You do not have to serve any notice. What you do is, before filing when you're done with the petition, when you're done with the appointment of arbitrator, it is called request case in the high courts. If you'll go to high court, these cases are called request case. The cases for appointment of arbitrators. So when you are done with your request case and you are going for filing, what you do is you serve a copy to the registered email ID of the opposite party or the address of the opposite party, and with that acknowledgement that you have served with an email or with the post to the opposite party, you affix that acknowledgement, the email that you have sent, and then you file.
सर मेरी आपसे एक रिक्वेस्ट है, Q&A बॉक्स में जो क्वेश्चंस हैं उनको हम कंसीडर कर सकते हैं क्या?
Sure. मैं एक बार बस कर रहा हूँ अभी. Have not Hiren Dhruv have asked, have not received payment from Himachal State Government Electricity Board. Material delivered in March this year. Have also sent a request over mail to the director of the organization, who is an IS officer. Okay, Hiren Dhruv ji, if your MSME registration is of prior date before entering into the transaction, or if you have generated the invoice after you have obtained your registration, then what you can do is I've facilitated a filing in Himachal Pradesh MSEFC. What they do is whenever you'll go and you try to file a reference before them, even online, even after accepting the cases online, they'll give you a form, and they'll give you a printed form in which particulars would be mentioned. You'll have to just write the details as it is mentioned in the form. They'll provide it to you, and after which, after affixing the documents and after filling out that form, you just go and you submit that form to Himachal MSEFC, and then your reference would be converted into the case. So I hope it is clear, Hirendra. You just have to visit the MSEFC office in Himachal Pradesh, and you just tell them that you want the form which is required for an enterprise to submit a reference, and they'll give you a form. So that form is really necessary. They have a form of their own which they require you to fill. So you get that form, you fill it accordingly, and you submit it before Himachal Pradesh, and they'll convert your reference into a claim case. And Santosh Khote has asked how MSME platform will help us to recovery of payment. I've already dealt with this in my webinar, Santoshji. I is clear to you. If you have any specific query as against any dispute of yours, you can contact me through Richa and Megha. Okay, Samita Kanekar said it's not audible. I'm sorry, Samita. Priyal Agarwal. Sir, when filing for the application under MSME, it's showing that bills should be prior to 17/2022. Why is this showing? Now, it is a very good question. I've also faced issue. I guess this is a technical issue, or in my view, it might be this is too much soon to have a case registered because it's just 1 year prior. So it not be because 45 days credit limit is given under the MSMED Act. So there should not be a reason why they tell this to you that your should be prior of August 2022, but via online mode an enterprise is not eligible, is not being made to make a reference for a bill which is prior, which is after August 2022. So the bills which are prior of August 2022 are only allowed for filing of the references in online mode. However, I think that you can file the reference for this invoice in offline mode, they won't reject it. But there is this problem while you make an online application, because I have faced this issue too, and I do not know why is this showing. We'll have to write a representation to MSME, Ministry of MSME, or we'll have to make a writ application, a writ petition before the High Court, which can only be done when a specific issue arises. So if you're not able to make the reference, I would suggest you to make an offline reference. And even if they do not accept it, then we can go to writ petition. However, we can even go to writ petition now because they are not accepting it via online mode, but that would be a futile exercise if you would consider my opinion, because you still have an alternative remedy to go and file it offline. So try to file in offline mode. If they do not accept it, please contact us. We'll get your issue resolved. Thank you. Vishwanathan S asked, I have a question on category. What happens if an enterprise fits into the investment criteria for a micro, but will fit into the turnover criteria for a small? Then you would be upgraded to a small criteria. It won't be a micro criteria. So if it exceeds, the upgraded definition applies. Rajeshwari Fade asked, can we get a recording of the presentation? The recording of the presentations are uploaded on our YouTube channel in way of videos. So you can always go and watch our webinars. We are on YouTube. There are 5 members, which are of which has me as their speaker. There are other very qualified speakers as well, other legal experts also, who have conducted webinars before. So you can pick and choose webinar whichever seems convenient to you. And thank you so much. Can MSME helps out for collection of amounts from customers? I do not understand this question, because MSME is an ministry. It does not indulge in any private collection drive, but it gives a dispute resolution mechanism for the enterprises to come and to file their cases and to recover the amount which are due. Now I come to Deepak Gulati's question, which is, sir, in case of checks, now positive pay system is started. What if issuer do not comply same? The bank will not give reason of insufficient. In this case, what will be status of check? Deepak Gulati ji, whenever a check is dishonored, in law it is mandated for banks to issue a memo to the check holder saying that this check has been dishonored and this check has been dishonored for this reason. And if it is dishonored for insufficiency of funds, then it will be recorded there. I do not know what is positive payment system, but I am sure that it must comply with the legal requirements that the bank has to issue a memo whenever a check dishonors. And if you receive a memo, if you were a check holder and you presented check to a bank which was dishonored, and you were presented with a memo saying that this check was dishonored because of insufficiency of funds, then please issue a notice within 10 days of time to the opposite party for a demand of payment. And if the payment is not made within 30 days from the date on which you have issued the notice, then you can file a civil and a criminal case simultaneously against the signatory or the enterprise who issued the check to you. Thank you. Thank you. Now is Mandala Bindu's question. Sir, if the company is MSME registered and there is an agreement between the parties contains an arbitration clause, in case of delayed payment, should it proceed under MSME or arbitration? So, as I already stated in my webinar, the MSME has an overriding effect on arbitration. So even if the agreement has an independent arbitration clause, if you want your reference to be conducted by MSEFC, you can go and file a reference before MSEFC. Then the MSEFC would have jurisdiction irrespective of having an independent arbitration clause in the agreement or not. So I hope I'm clear. Now is Kaushik Gali's question: what if payment is due from the government organization? You can also approach MSEFC, even if it is due from government organization. You can also approach arbitration. You can also invoke arbitration and conciliation. You can maintain a civil suit against a government department, and the only thing which you cannot do is to proceed in IBC. Otherwise, you can proceed in all the other laws against a government organization for recovery of your money. Next question is Venugopalan Saragopan. Thanks for the delayed rundown of provision role of RXIL. I do not understand this question. I do not know what RXIL means. So, if possible, kindly please state what is RXIL. How to handle group of companies if one defaults in payment. Oh, that is a very jurisdictional issue questions. You'll have to read many case laws which are on this specific ground. So there are the group of doctrines in Arbitration and Conciliation Act which states that if a transaction is indivisible uh, in a way of entity, like if a group of company has entered into a transaction with any enterprises, and if any group of companies, one group of companies from that one company from that group of companies was entered into a transaction with an enterprise, but the transactions were of such manner that the transaction cannot be visible as security. It cannot relate back to that specific entity, that group of company with whom you entered into the contract with. If it is that case, then the group of companies can be made a party into an arbitration proceeding. But in most of the cases, the signatory of the agreement can only be made a party to an arbitration agreement, or be it an MSME proceedings or be it arbitration agreement. So we'll have to check the transaction, the nature of the transaction, the documents which are there, which are present with you, for me to understand, for me to advise you accordingly, that if at all you can invoke the group of companies doctrine in invoking arbitration or not. Second is Vishwanathan S. I have a question on category. What happens if an enterprise fits into the investment criteria for a micro bit of I already answered this question. Santosh Kharote has asked again, we are building very contractor from Mumbai. Our client is Cooperative Housing Society. They are not paid our final bill payment, but at the same time, they do not deny it. Then what you can do is you can approach the MSEFC for delayed payment recovery. Then you can provide all the documents in which they have accepted the amount, but they have not paid the amount. Just go and show a certificate from your bank stating that this cooperative society has not paid anything to me as of yet, or has paid only this much of amount as of yet to me. That certificate would be issued by your bank to you, that the cooperative society has paid only this much of amount to your account, and you can show the bills which has been raised of this amount, but the payment has not been made in full. And for the part payment, you can go and approach the MSEFC, and I hope that it would be recovered if it is not denied. Thank you. Kaushik, there is another question. We are registered MSME and manufacturer for defense ordnance factories. Okay, Yantra India Limited. Our payment was due on 24th May 23, and still it's not paid. They simply say no funds available. We cannot afford to pick a fight with the customer, as it may affect our future business relationship. So what if it also has this disclaimer that you do not want to pick a fight with the customer because you do not want to ruin your relationship with the customer, but at the same time you want money from the customer, and they have simply denied, saying that they do not have any funds with them. Then the only option is with you is to approach the courts, right? And if you approach the courts, you will be in a way picking up the fight with the customer. So just be sure enough first whether you want to go to the court. Is it too soon to approach the court? Because as I can see, the bill amount is of 24th May 23 only. It is not it has been around 2 or 3 months as of yet. But if you are really facing financial crunch, and if you think that you really need that amount for you to survive, for you to run effectively, then you must go and you approach MSEFC. You issue a notice to them at least that you are making up your mind to approach MSEFC because you need the amount so very badly. And if they do not make the payment, you can file a reference claim, and hope that it gets resolved. Thank you. Why medium enterprises are not being able to get the benefit of this act? Because the legislature thought that the medium enterprises have resources enough and have uh, transactions good enough. They are big enough to know of all the recovery clauses. They do not have that they are not suffered as much as micro and small enterprises, right? Because micro and small enterprises do not have a lot of financial liquidity with them, and the medium enterprises generally are enterprises who have turnover above 250 crores. So it is understood that they have a lot of liquidity crunch with them. So if even if it is delayed for some time, or if it is not paid on timely basis, the benefit to of MSEFC is not extended towards them, because the MSEFC benefit was extended to the micro and small enterprises on the apprehension that they will resolve the disputes as soon as possible, and they would recover their payments as soon as possible. But it is not, they do not feel the need to extend the same benefit for the medium enterprises. The medium enterprises have enough resources to draw out arbitration clauses, independent arbitration clauses in all of the agreements. They can draw out agreements for all the transactions. So they do not have the lack of resources as the small and micro enterprises have in businesses, right? They are the small businesses. They do not have market share. They are not as much rich in sense of having turnover or having transactions of that sort. So the benefits are only provided to micro and small enterprises. I hope I'm clear. And is there any other questions that you have? Okay. Rohit Acharya has asked, there is a court ruling which says that MSME registration date has to be before invoice date. My invoice date is 2019. My MSME registration date is 2021. I filed MSEFC case in 2021. Since 2 years, I am fighting this case. Now they are saying after 2 years that case cannot be heard. What recourse do I have? You do not have any recourse, because in 2022, Supreme Court in a batch of petitions made it clear that the MSEFC would not have jurisdiction if the invoice date is prior to your date of registration. Now, even if you had made that reference, it was still pending. The case was heard before the Supreme Court. It was sub judice before the Supreme Court. And now, when the judgment is out in 2022, it does not matter whether you have filed your case in 2019 or 2022, whether they were hearing your matter for 2 years. The law of the land as of now states that the MSME does not have jurisdiction for the invoices which are prior to the date of registration of those enterprises. So from that date, all those references are returned, and all those references were terminated, saying that they do not have jurisdictions. I've come across a lot of those awards in which the MSME has denied that they cannot hear it any long, or they cannot hear it any further because of the Supreme Court decision. So in that case, your limitation period would not expire, because the time period in which you wasted before wrong tribunal would be exempted if you go and if you opt for the new recourse right now. So nothing has changed now. You just have to change the recovery platform. You cannot go before the MSCFC. If you have the arbitration clause, you can opt for arbitration, or you can go for civil recovery. To avoid non-compliance debtor asking MSME institution of letter, we can we issue such letter? I did not get your question, Seema Gavde. Can you please be a bit clear? Is Seema Gavde here?
सीमा जी, आप अपना क्वेश्चन पूछ सकते हैं सर से।
Hello, इतना है ना?
Hi Seema. Hi.
Hello, sir. Recently,
Hello.
we faced such type of issues that some clients are asking us the waiver letter, that we
Waiver
should
letter.
ask some penalty in future for late payment,
Okay.
delayed in the payment.
Okay. So they are asking that even if we delay, you write and you give a waiver that you won't ask these delayed
Penalty,
payment
right?
interest or the losses from us. No,
Correct, sir. Correct.
you should not, as a business, you should not give those waiving letters, because it would hamper your claims at a later stage of point, because as per contract, you yourself would have waived off your claim, right? You would say that you won't at any time in future would claim the delayed
Okay.
interest or any sort of delayed claims. So all these things, all these demands, you should not concede to. You just ask them to make the payments in timely basis. I do not know why they want these letters in the first place. It actually shows that they want your payment to be delayed. That is why they
Right,
are
sir.
wanting these letters in the first place, right?
Else,
So
else what
yeah.
happened? Else they
Yeah,
are
so
asking
you
to
should be
us
you should be
to
careful
view the
enough while
current
dealing
dated
these. Yeah.
invoices.
Okay, so they are asking it to be included in your current invoices.
Right, sir.
But you should not do it, no, because if they choose not
But
to repay you, then you won't be uh, able to claim the interest amount from them. They would conveniently delay your amount for, let's say, 5 years, and the only liability upon them would be of the invoice amount, which was the same before 5 years.
okay,
So do not give them this leeway, because if you give them this leeway,
okay.
they would conveniently delay your payment.
But what happened till date? We are means we blocked the fund. Na, that was our issue. We are not a that much means big employer.
Okay. So you can give a conditional waiver of letter if you want something of that sort to be drafted. I can help you with that.
Okay,
It would not give complete waiving off, but it would just extend the credit period to, let's say, 6 months. So MSCFC
oh,
gives 45 months. You can say in your invoice that I give it to you basing on the provisions of MSME. Even after knowing the
okay,
provisions of MSME, I extend it to
okay,
60 days. And till 60 days, I agree that no interest would be applicable. But after 60 days, the interest as per the MSMED Act would be applicable. In that in
okay. So
that
we
way, they
can
are getting two months of time, right, to make
extra
the
period,
payment.
right? Right, sir. Got it, got it. And is there is any necessity that front one should be a MSME registered? That debtor or client?
No. Your client doesn't have to be MSME registered. Only you, if you want to get recovery or get your dispute resolved from MSME or MSCFC, then you should be MSME registered enterprise, not the other one.
Yes. Sir. Okay, okay, no issue. We are.
Oh,
Yes, thanks a lot, sir.
thank you so much.
सर आई होप सभी की क्वेश्चंस हो गए हैं.
Varun Agarwal asked, my payment is stuck from last 4 years. Can we have Varun Agarwal, last Varun Agarwal,
Yes,
for
yes,
the
yes.
question?
वरुण जी आप अपना क्वेश्चन पूछ सकते हैं
Hi
सर से.
Varun. Hi Varun. You're muted, Varun.
सर इनका माइक म्यूट है.
Varun, you can reach out to me by reaching out to Richa and Megha on their
Yes.
email ID. It is already chat box. So
सर ऑल डन.
all the questions are done.
सॉरी सॉरी सर
All the questions are done.
सर Q&A बॉक्स में जितने भी क्वेश्चंस थे सारे कवर हो चुके हैं आई थिंक.
Yeah, I answered all the questions. वैसे तो
यस सर.
I'll just check. Yeah, I answered all the questions. Yes.
ओके सर. सर थैंक यू सो मच सर. आज के वेबिनार के लिए काफी अच्छा वेबिनार
Thank you.
रहा.
Thank you.
आई
Thank
होप
you so
सभी के
much,
क्वेश्चंस के
Janet.
आंसर
It's
मिल.
always a
थैंक यू सो मच सर फॉर जॉइनिंग अस.
thank you. Thank you. If anyone has not gotten their answer, you can reach out to Richa and Megha, and they will redirect to me, or they can connect you to me.
ओके सर
Thank
थैंक
you.
यू सो मच.
It was wonderful. Thank you. Bye.